Wow, look at that. It's almost a professional environment. We look sophisticated and mellow. And so I threw out the professional. There we go. Let's mute that tab. How's everybody doing?
Good.
Good.
Doing all right.
And I've got the two Steves. I like that. So we're blanketing. I wish there was more Steves, and it could be the Steve cast.
It's already stereo, so that's got to be great for everybody.
Oh.
All right.
There's Nate.
Nate is here, and we may have Joe coming. It's my fault. I forgot to invite him yesterday, so I got him this morning. I was like, "Hey, Joe, did you want to come on?" That's why he's not in the thumbnail or the description, but hopefully he'll be joining the show. Folks, I got to say, this is going to be a short show. Nothing happened this week, so thank you for coming. Have a great day.
Thanks for inviting me. Bye.
Bye. No. So where do we start with this crazy ass ridiculous week? How about Monday? Because Monday we had two events happen. One that was an actual event, and the other was kind of a relief with Don Lemon being sacked. But Tucker Carlson wasn't fired, it turns out. Tucker Carlson still works for Fox News. They just said, "Oh, you have no more email access and you have no more show. So just sit at home, shut up, and collect your check." Now, I bet you guys deal with contracts and things like that. So what are your opinions? Steve.
I don't know.
Oh my God, hold on. Steve Gosney is obviously new to this, and he's a professional. He doesn't know that you're supposed to jump in like there's food that's on the table and somebody's going to grab it. So you jump in to grab the food.
Well, the thing is that I don't do employment law. I do criminal appellate law. And so this is a contract employment law issue. I have opinions, and I did do contract litigation when I was prior to criminal law. But so I was hoping that somebody here who practiced in the civil arena might jump in first.
Other Steve.
Would you like me to?
Go ahead, John.
All right. So as a practical matter, and I've worked in the civil arena, not necessarily in employment law per se. However, I've certainly done contracts evaluations. I thought that his particular statements yesterday, which I don't know if you have that lined up, Eric.
I don't. Right, my bandwidth. I'm on the road, so my bandwidth's a little.
If you can pull it up, it says a lot about what he can and cannot say.
Mm-hmm.
But
vague. It was such a vague statement. It was a complete mystery. It's like, what the hell is he talking about?
But he alluded to a lot of things that I think you can draw inferences from. I wish that we had that available to us. However,
you can always share it too, dude. Everybody here can share a screen.
Do you want me to pull it up?
Absolutely.
I'll pull it up.
Okay, Nate's going to pull it up he's on mute. So I psychically know that Nate is actually pulling it up somehow.
I was going to cover that yesterday, but it'd be as valuable to do it right now.
While we're pulling that up, though, I think it's very interesting. Did anybody notice that he has the new lawyer, Brian Friedman? Brian Friedman is the guy who clawed back $30 million for Megyn Kelly. Yes. He also is working with Chris Cuomo. So Megyn Kelly is the one who broke the story saying, oh, by the way, he still works for Fox. He's under contract. Oh, and gee, what a coincidence that Chris Cuomo suddenly has Bill O'Reilly on his show to talk about the situation. I wonder if this lawyer might be doing a little bit of coordination. What are your thoughts?
Absolutely. All right. We can either run the show or I can give my comments. Which would you prefer?
Let's go ahead and play the clip, I guess.
Okay.
2 minutes.
Good evening. It's Tucker Carlson.
One of the first things you realize when you step outside the noise for a few days is how many genuinely nice people there are in this country, kind and decent people, people who really care about what's true, and a bunch of hilarious people. Also,
once again,
it's got to be the majority of the population, even now. So that's heartening. The other thing you notice when you take a little time off is how unbelievably stupid most of the debates you see on television are. They're completely irrelevant. They mean nothing.
Would you be
in 5 years? We won't even remember that we had them.
So, when you're talking about unbelievably stupid debates, that is a direct shot at your corporation and the way that they format how they run their shows. And please tell me if anyone disagrees with that.
Well, it could be that or all competitors. I mean, yes.
I agree with anything you say negative about cable news shows, any network. Just give me a thumbs up automatically for that.
I kind of want to. Steve Gosney, I don't know you very well. I'm just meeting you, and it's nice to meet you.
Thank you.
I don't know what your perspective is. I'm really interested to hear what Nate has to say on the subject.
What are you doing, Nate?
Nate's not going to put his opinion out.
It's like we had to
guy. This is
a
standing opinion.
A lot easier if I go here because it's like you get all this feedback. I'm on my own computer over here. It's like it's not working over here. So I'm like,
wait a second now. There's some. Wait a second here.
So we can all reach into each other's screens here, and I don't know that people know that.
Taking over both screens.
This is total inception, folks.
So here it is. I'm on both screens.
Stereo Nate.
We got Nateception.
Yes. Let me take this off because I'm hearing everybody in like double talk here. But listen, I think, to be honest with you, I think Fox News. There's a Wall Street Journal video that just came out. Now, for those of you who don't know, Wall Street Journal is owned by News Corp.
Rupert
Murdoch, and they put a hit piece out on Tucker, allegedly saying that Tucker is fired because he was racist. He was fired because he was misogynist and all this stuff. And by keeping Tucker under contract for the 2 years, one of the best things that can happen in this situation is that he can't respond. Because generally what happens is that, you guys obviously know in civil, the buyout, right? There's usually a buyout clause where if things don't work out, we can buy out for the rest of the contract at a discount or a premium. Fox News seems like they're not taking that option. They want to, keep him to the contract. And I think that's got Tucker in that bind. And I think it's interesting because from the reports, Tucker's getting paid like $1.2 million a month. So Fox essentially is going to pay him the $1.2 million a month to keep his mouth shut. Is that worth it?
Do you think George Soros could afford it?
I think, yeah.
Well,
I think.
Let me ask you, Nate, before you leave.
I'm not leaving. I'm just
real quick before you leave the chair. Do you think?
See? Go ahead.
Do you think that? Because I remember, I guess, what does he have? He has another year and a half in his contract.
Yeah.
Is silencing him worth it? And do you think that he might not be able to have another option that he would sever his contract? Because I'm going back to his executive producer decided to leave the company as well, which to me suggests, because usually a producer stays with their talent. Don't you think that they have some sort of something in the wings?
Oh, he's probably doing reconnaissance or plan. I mean, they're obviously plotting and planning. And so the producer, he's a free agent. He can do whatever he wants through
they
the
actually offered him to produce the 8:00 show for Fox, and he said no.
Well, he's going with the talent, which is smart.
Which is smart, right? The talent, yeah.
The issue I think is you have a non-compete clause. That's the question. Is there a non-compete clause? How enforceable is that? Number two is this they're giving mixed messages on the termination. He can walk away from the contract and not get paid, right? I think that you you can't contract slavery, right? You can walk away from any contract. You just relieve the other side of their obligations. As an employment situation, you can't force somebody to work. So the contract is basically one-sided on the part of Fox because they're giving him monies in order to accomplish whatever they're doing. Well, he can walk away and do something completely different. He just isn't going to get paid. Now the thing is the non-compete agreement is the question. So is how much of a non-compete and how enforceable is that over time, and how long is it in effect? So right now he's getting multiple offers from multiple jurisdictions, weighing them. And if he can get paid $2 million a year or $2 million a month, then he can walk and do away with his $1 million a month from Fox and benefit. So now he's in the perfect situation. He can weigh his offers. My only question is how much of a non-compete agreement is there within his employment contract?
My issue there is, and I am a licensed attorney in the states of Florida and New York. Just so everybody knows, there might be people that don't know me.
Well, fortunately, you didn't shave, so we have hope.
So in New York, non-competes are virtually unenforceable. So the question is, what is the actual domicile of the contract? And I don't know that because that hasn't been revealed.
Well, I kind of have a different outlook on it. I think when Tucker contract, as long as he's under contract, if he breaches that contract, you do have a material breach of the contract, right? It's even though I understand it's an employment situation, he's giving up that right to seek other employment by coming into those terms of the contract. So I don't know what the penalties are listed in the contract, but here's the
problem, Nate. Here's the problem when you come up with that sort of a thing, because I have dealt with this before.
Mm-hmm.
You have to have the whole point of a non-compete is that it has a jurisdictional relevance, and it can't be all of it. And so non-compete laws under New York contract law can't be all of it. So if he were to go to an internet platform, or if he were to go to a platform that the difference is between, ABC 8 and NBC 6. Okay, fine. There's a non-compete there that maybe you can enforce. But
John,
you cannot have a universal non-compete.
But the issue with the non-compete argument that I think it may just be too early for the non-compete argument in this instance. If he's still an employee, the non-compete is not that. It's, in other words, if he was fired, then you have the non-compete, because usually non-compete says you can't do anything for 6 months, right? After you've left or we've ended the contract. But if he's still under contract, we're not talking about a non-compete. We're talking about, is he going to materially breach the contract?
But here's my point from that perspective is...
Time out. You're all talking about Don Lemon?
I know. Absolutely.
Unfortunately not at this point.
We were brokenhearted. Don Lemon got sacked, and we were just weeping.
Journalism will never be the same again.
No, not at all. They lost all 13 individuals at the Poughkeepsie airport.
Yeah, definitely.
I'm sorry.
Anyway,
go I'll let you guys proceed before I try weighing in.
My point at the general premise was, if Tucker wants to leave, a non-compete clause is not going to be particularly effective, in my opinion, precisely because New York law, and I don't know where it's actually licensed. I don't know where the contract was actually forged, so to speak. But under New York law, I don't think that the non-compete would be effective.
Well, we don't have the contract. One of the problems here is we're talking in a vacuum because we don't know the terms of the contract. We don't know what it's good. So there's a big issue there. The second thing is that we also do not know exactly what the terms of the contract are. So by shutting down his show, Fox could be effectively terminating him, even if they say he's not fired. They are in effect firing him, depending on the mutual obligations of the contract. So until we know the terms of the contract, they could be breaching by their actions, even if they aren't saying it. So, and that's probably why he retained counsel to deal with this. Meanwhile, he's weighing all his options. He's going to find out what he wants to do, and he's going to act in accordance with the contract that he knows and his lawyer who knows. And so I'm a little concerned about us speculating without having the terms of the contract.
Well, do we actually know what state the leading grounds of the contract is? Because if it's New York, I can find it pretty easily. So,
but we don't. But how can you opine on it when you don't have the terms of the contract?
Right.
Yeah.
I'll tell you what.
So let me say this from a civil perspective, following up on Steve's point, which is not knowing about the contract, is if Tucker wants to appear on someone else's show, network, or whatever, one of the things that's an issue for non-competes that I deal with, or used to deal with businesses a lot, still sometimes, is the place you want to go to, they want some certainty about whether that non-compete is good or not, because they're going to get sued for interfering with the contract. They're the ones who are going to get sued. So my guess is, there's lots of negotiations going on right now to clarify what Tucker's possibilities are that wouldn't involve litigation. So if he doesn't want to set up his own thing and wants to go to somebody else's place, they can be assured if they enter in a contract with him and put him on set somewhere, they're not going to get their rear suit off, because Tucker's very popular. You put him on your show, you pay him a lot of money, and then Fox comes after you for damaging their business because you interfere with the non-compete that he had. So you don't want that. So there's a lot of things to triangulate in this, not only the jurisdiction like John and Steve have talked about, not knowing anything about the contract, but it's not just Tucker and Fox, it's wherever Tucker wants to go. And if you don't settle that first, that's an issue.
There's other
Southern.
Like, what about, sorry, Joe, I swear I'll give it to you. You have other players like a Spotify who could come out of the left wing, because you're talking about different mediums as well that maybe he could jump on or sneak inside. I don't even know. Or a Joe Rogan deal could come up.
That seems unlikely. That seems unlikely.
Well, I don't know. I mean,
I'll tell you why. I'll tell you.
Money as an example.
Oh, yeah.
You certainly need to think to yourself. Who these? We don't have a copy of the contract. So what we're left doing is we're speculating. And the contract, as everyone here knows, and is the first day one of law school, contract governs. That's what's governing everything here. Now, the contract could be modified if in some way it tries going outside the bounds of law, like a non-compete agreement, which would be too long in duration and scope. That
the idea would be an unconscionable.
Would be curtailed, right? But I don't think it seems, if we're just using common sense here about the parties involved, it seems unlikely that Fox would be so foolish as to try to create a non-compete that's long. It also seems unlikely that Tucker's attorneys, he almost certainly had well-paid attorneys negotiating this contract for him, would not have foreseen the possibility that he could get fired and what would happen in the event of a termination. And because the role of a contractual attorney, which we call a transactional attorney, is to basically try and foresee every nightmare outcome that could, reasonably be predicted that could come during the course of a contract, and how to best insulate your client from being suffering negative effects as a result of that outcome. One of those likely outcomes you would think someone who is an attorney negotiating on behalf of Tucker is, well, what happens if your show gets canceled? I would be surprised if there is not a specific clause in the contract which lays out step by step what the rights of the parties are, what Tucker's rights would be, and put something in there, perhaps saying that Tucker, if his show gets canceled, that he has the right to decide whether he wants to remain under contract or to opt out of it, and how that would all work. This is almost certainly something that is there in black and white, because he's not the first person to be fired. He's not the last person to be fired from this kind of gig. And attorneys in the entertainment industry are going to put in the employment contract exactly what will happen to their client in that scenario. So I think we're all speculating as to what, the law would say, whatever, but the reality in this particular circumstance is it's almost certainly pretty carefully spelled out in his employment agreement.
But here's the problem, Joe, is you are expecting that attorneys are actually good at their jobs.
That's
we don't
true,
know.
but that's
When
true.
you get a certain level,
But
I think
he was a pretty wealthy guy before this, and people who are pretty wealthy tend to find pretty good attorneys. I mean,
I'm saying Fox's attorneys, I think, were not particularly fantastic, because why would there be the potential specter of him suing for them to pay out the rest of his contract and relieve him of his obligation?
well, you have to realize that a lot of his
To be
That would be a buyout.
there would be
Like-
yeah. I mean that
like-
there could be that, and you
Well,
also
why wouldn't that be a contractual buyout as opposed to him having to actually enforce the contract?
Like generally, like again, this is with us not knowing what the contract is, but generally the way it works, like for instance, what happened with Megyn Kelly. When Megyn Kelly was let go from NBC, they bought her out. So I think she had like another 2 or 3 years on her contract, and she was owed like 35 million, but they settled for like, all right, we'll give you 30 million just walk away. So she took that and walked away. So in other words, we'll buy you out at a discount. And a lot of those contracts, especially with NBA players and things like that nature, they'll have standard buyouts where it's 75 cents on the dollar if you can't last the full term. So I don't know what Tucker's contract has, but the fact of the matter is that right now we're hearing that he's still under contract. So in other words, they didn't fire him. They're saying we're going to cancel the show. So does that mean now he can just say, okay, I'm just going to walk away from this contract and go do my own thing? I think there are financial penalties or there's something in that contract that doesn't allow him to do that, because if it did, I don't think he would be looking for this, it wouldn't go this route.
another question
Nate,
on this.
Can I jump in real quick? Nate, if he were to do that, why would he have put that Twitter conversation up saying, "I'll see you soon"?
oh, it could be that he's weighing 7 different options.
He's waiting
Yeah,
for
and he's just throwing things out there. But Steve Gosney,
You can't throw things out there if the alternative is taking the contract for the next 2 years, whatever the hell it is.
well, it's a negotiation. You can throw anything out there.
a year.
You're just making a
Fine,
statement.
you can do that. But if you're off the air for 2 years, if we never hear a word from Tucker for 2 years, then that's basically a death sentence in terms of coming back. I mean,
Right, now, hold on.
nobody
That's-
has ever been able to build a
Ian.
comeback like that.
But
Yes.
Megyn Kelly kind of did.
Hold
I mean,
on.
she kind of disappeared for a long time.
Not that long. She did go independent and built her own channel. But Steve Gosney, this reminds me of music artists. I know you're a musician, and I think both Steves are musicians, guitar players. This is a common tactic with a band. Like if you have an up and coming band, you'll hire that band and put them under contract for an album. Then you stick the album on the shelf, and that band has now been effectively frozen because there's a bigger act that you want to protect. Isn't there a recourse? And I think this is where John is going, that an artist has to be able to perform or do their thing. Like there might be some laws or whatever saying you have a right to express yourself or to practice your trade and not be frozen from all existence. So I'm gonna give that to Steve.
Steve, go ahead, Steve.
Well, actually, you know what? The interesting case, it's kind of a precedent-setting case that has to do with music artists wanting to perform is MCA Records versus Olivia Newton-John from 1979. And she actually signed there was a breach of contract about that, and there was declaratory relief about being able to perform and get out of contracts. People need to understand that, and I did civil law for a while. I didn't do employment law. I did contract law. So if you want to look up the Olivia Newton-John case, that will give you some guidance. I will say that there is no slavery in the United States. You can't create a contract that creates servitude. So contracts are generally one way. That means that you give a contract there was something we used to call when I actually negotiated contracts. Before I was a lawyer, I had to deal with employment contracts as an employee, being hired as an executive officer. We had a saying that an employment contract is really a separation agreement, because it only is operative if we have an agreement. There's no issues. It's only when we fail, when we wish to separate, do we wish to clarify the terms of our separation. And so I think it's highly unlikely that Tucker is going to be in any kind of agreement wherein he is going to be silenced for a long period of time. I think at this point, it seems to me that Fox is paying him under contract to kind of control him. But at some point, he is going to exit. And that is what his contract lawyer that he's hired, his employment lawyer, is doing, is negotiating his terms of exit so that he is free to pursue whatever he wants. And like I forget who was talking about non-compete agreements. Non-compete agreements are very much disfavored in the law. So obviously you could sue for a declaratory judgment to find whatever clause is in there. What are the terms? What does it constrain? But then you're involved in a legal process. It's much better to negotiate an exit in which Fox is relieved of financial obligations. They do mutual releases, and then he goes into a new situation. So for him, but see, I think this was a little bit unexpected for Tucker. So right now he's in a great situation. He's getting paid, and while he's developing and weighing all his different options, once he comes up with it, then you're going to have to look at the terms of the agreement, have an employment lawyer, and negotiate that exit, and it's going to be a smooth transition. I doubt you're going to see a Tucker silenced for any long period of time.
I would say that the non-compete agreement probably would prevent him from just going to an alternative media the way Eric was suggesting earlier. Because if you think about it, if he was still doing his nightly show and he decided he wanted to just branch off and start doing some Spotify deal a la Joe Rogan, that probably be something that, while under contract, he'd be prohibited from doing.
Well, and we don't know. I mean, there may not be a non-compete. I would expect that there is, as long as he's getting paid. As long as he's getting paid by Fox, he is not going to be able to go and do that. But until he finds where he wants to go and what he wants to do, he's not going to disrupt the paycheck, the $1 million a year a month paycheck from Fox, right? But once he decides where he wants to go and what he wants to do, that's when all this stuff comes to the fore. And until we don't know what's in the contract. There could be non-competes, there could be payouts, there's all sorts of things. His new employer, there could be a liquidated damages clause. His new employer could come out and say, well, we'll pay your liquidated damages. We'll handle the litigation. You come with us, we'll pay $1 million and we'll handle this. So, it's all up to negotiation between the parties. I think Tucker is in the stronger position, though, because he's the one getting paid. He's the one with the contract, and you can't enslave people with a contract.
Well,
go ahead.
Well, two things. Of course, slavery you can't do, but there are certain rights that you can restrict yourself within a contract. I personally will contracting to do this or to not do this, right? So there's a difference between saying Tucker has to do a certain thing versus we're going into contract and saying we're going to have these obligations together. I think in this particular case, if Tucker, there are two issues. The big one issue is for the next company that wants to hire Tucker, because now if they're trying to get Tucker to come onto their stuff and do their stuff, they may have a cause of action against them for if they find a material breach of Fox's contract between Tucker, right? I want you to breach the contract with Fox to come on with Spotify. Then Fox can sue Spotify and say, hey, you forced him to breach our contract. It's, that type of thing. Then I think you have the second issue where if Tucker is getting paid, and let's say he says, I don't want the money anymore, I just want to walk away. Then this is where it goes back to the contract. Well, because they could say, okay, well, there may be, like you're saying, some liquidated damages. So I think Tucker, the financial piece of it with Tucker may not be as harming to Tucker, but I do think those other companies may have an issue because those other companies will have to worry about Fox coming after them for Tucker breaching his contract to work for them.
I doubt that because, see, I think right now they have effectively terminated him. They've terminated him as a de facto matter. So, whether or not because they've taken his show, I would expect that the contract, I don't think that a lot of our fears that we're projecting into it, I doubt that they would exist. I don't think Tucker would sign such a contract, and I don't think that's the way it's going to work. I really feel like Tucker's going to bide his time, weigh his offers. At the proper moment, he's going to terminate his contract and get whatever terminate obligations from thing, he's going to walk and he's going to get his own thing. And all of making that happen, that's all up to the lawyers and negotiations. But him being handcuffed from doing anything in the future, I highly doubt it's right. He's not going to do it right now because he's under contract. But as soon as he's got the better offer he wants to do, he's going to terminate his contract. He's going to walk away. And then how that unfolds, the two things that it can affect it are what you said was that liquidated damages, number one, and number two is the non-compete clause, which are highly unenforceable generally. And I don't know New York law. Joe, are you a civil New York lawyer, right?
Mm-hmm.
And
so we don't know. We don't know. We don't know
this.
Yeah, we don't know that this contract is operating under the terms
We don't know
of the state of New York. It could be DC. It could also be DC.
Yeah,
in New York, I believe my recollection is that the maximum duration of a non-compete agreement would be 2 years, and it would have to be limited in scope. Also, that's my recollection. Although if someone showed me something saying that was 1 year, I would be mildly surprised, but not.
And see, I think I have one more angle to this, and that is that the reason that Fox is not firing him is because if they fire him, then they're obliged to pay out the full term of the contract.
Yeah,
okay, so if they retain and pay $1 million a month, he's going to eventually walk and terminate the contract. Then they're not obliged on the back end.
I saw reports saying that they let him go for good cause, implying that it was a firing for good cause, and that's their position.
This is all negotiation.
Eventually, when they say for good cause, just to clarify from that's a legal term of art. Because in employment law, there are three different bases you can fire someone for: either good cause, bad cause, or in between, which would be no cause. So good cause would be, let's say he said something terribly like it was genuinely racist, or which they might try to claim, or if his ratings were just in the tanker, which they obviously were not, or if he was some sort of legal liability because of different defamation that he was protecting. Those would be the sort of things which one would expect to be qualified as good cause, and that helps protect the employer when they can properly state that claim in court, and the court recognizes that it was good cause as far as the impact of the termination and their respective rights and obligations. Bad cause is if they fired him for some reason that they're not permitted to fire for someone. Like, let's say they said it's because let's say he came out as being a homosexual, and they said because of that we don't want to have you here. That would probably be something that would qualify as bad cause. In other words, you're showing real racism in the firing. That would be bad cause type of thing, or misogyny, that sort of thing. If no cause is basically like, yeah, we changed our mind. Now that tends to be less applicable when that's really more an at-will employment when there's not a binding contract, those terms. But those terms are frequently thrown into a contract if termination is for good cause. In that case, Fox has these duties and rights, and Tucker has other duties and rights, as opposed to bad cause, as opposed to no cause. That's why, even though it's not technically something that's binding in a written contract, it very likely will play in here, and it makes sense why Fox would publicly take a position of, we fired him for good cause, because if they fired him for good cause, that gives the most leverage as far as what claims they can make down the road.
Okay,
but that also leads me to think that he really was fired, though, because I heard that report.
Joe, let me add on top of that, because the question was about a non-compete. So, what are actually the requirements of a non-compete being valid? And so I want to say that for a non-compete to be valid, and this is according to New York State Department of Labor, which, they have their own way of things. Give me 1 second.
Two things.
It requires one, that it be necessary to protect the employer's legitimate interests. 2, it does not impose an undue hardship on the employee. 3, does not harm the public, and 4, is reasonable in time period and geographic scope.
Mm-hmm.
And So a universal, you cannot be on the show anymore. I think under New York State's own rules, it would not be appropriate.
Well, we're saying you can't be on the show anymore.
Yeah, but see,
you can't be on the show anymore. You can't be on it. But do you even think that you can argue that you can put a non-compete that if Tucker said, all right, fine, I signed a contract with CNN,
okay,
that they could hold him on the no compete?
if he's still under contract with Fox and he's not, all right. So the only way the non-compete comes into play is if we have to assume that he is actually fired. They've ended that relationship. They said you're gone, right?
Why?
Then the non-compete kicks in. This happens. All right, this happens.
No, actually, I would put no. I think that's wrong. I think that if he quits, then the non-compete. If they
then
fire,
non-compete comes into effect.
So, all right, so that's what I'm saying.
He's still staying on the contract, but here's the problem.
Listen to what I'm saying.
Want your opinion on this?
Still working for Fox. If he's still working for Fox, the non-complete doesn't come in until that relationship is in. He either quits or Fox fires him.
No, that's not true. I disagree with you, Nate.
Right?
I disagree with you. He can't take a job with CNN while the employment is going on.
Because he's under contract. He can't.
Okay, but that's part of the non-compete. The non-compete lasts for the life of the contract plus 2 years.
Yes. That's so. All right. So this happens in professional wrestling a lot. For instance, in professional wrestling, this happened when WWF bought WWE now bought WCW. A lot of their biggest stars like Bill Goldberg and everything, they were under contract with Turner Sports for like another 2 years. So the WWE and Turner gave them all options. They said, okay, you guys have agreements where for after you end the agreement with Turner, you have to wait 6 months, but we'll buy out the Turner contract. And then a lot of those big entities, they said, okay, no, we're going to take our Turner money because I think like Bill Goldberg had 10 million. So he waited 2 years and got paid by Turner and didn't end that contract because he could have quit and let that money go and then go to the WWE, but he would have had to wait 6 months. So what I'm asking is that in this particular case, if Tucker is still under contract with Fox, right? Now he's under an exclusive deal with Fox. He can't go sign with CNN because now he would be violating the contract that he's under with Fox. Now, if that contract is over, that's when I'm saying the non-compete for whatever term, usually it's 6 months or maybe even 2 years, where he couldn't work for anybody else in that same sphere because he has that contract with Fox.
Here's the issue is that if you are using a contract in contravenance of what we would consider public interest, can you essentially take a public personality, fire them, say you can't have any more shows, but we'll still pay you for not making shows?
Yes.
And then hold you to a non-compete.
it depends on the contract. I mean, and the law, and we don't have the contract, and we don't even know what law, but we don't know what the jurisdiction is. So, it's like, because it could be New York, it could be Florida, it could be any state, it could be Delaware.
It could be Maine.
It could be California.
The choice of law. So
Washington, D.C.
So we're speculating. I would say that I really foresee what's going to happen is they're paying him because they don't want to pay out the contract in full. Now the question is, how much are they going to pay him, because they have effectively fired him, but they don't want to say it. Because if they fire him, they're going to have to pay him in full for the entire term of the contract, and he's released. So they're in fact saying, we're not firing you. We're paying you $1 million a month. See, if they fired,
I don't know. I agree with that, Steve.
No, if they fired him, they'd have to pay his contract in full.
Yes. It very likely is that if they have a right to fire him for good cause, and they might.
That's why they're saying good cause, even if they don't have it. It's a negotiating tactic.
But then they wouldn't have to pay him for the balance of the contract.
Well, so that's something we can litigate, or we can negotiate. Okay, so
I have one question that nobody's discussing here. Maybe the real value is that Tucker is benched.
That is the value for Fox. I think that's
all.
Yeah, but he's benched only as long as he doesn't have a better offer that he's accepted.
And
that's my point. Is
to shut him down.
All of the arguments. Can you contract somebody to shut up?
Yes.
Well, yes, you can. But I think the assumption that I think is being made here is that Tucker's contract was specifically for the show. Tucker's contract could have been to be an employee of Fox News, and as a consequence, hey, you do this, and one of the assignments was doing this show. You're going to host this show. And then he was doing Fox Nation. He was doing a whole bunch of other things. But unless that contract says specifically, you're only going to do this show, then they can say, okay, you're not going to do this show. You're going to do something else. We can have you working wherever we want to do, within bounds of the contract. So not having him on the show doesn't mean he's not an employee of Fox. Doesn't mean he's been fired. Only thing that means is that you're not on the show, but they're still paying him to be an employee of Fox News in another role.
Well, it depends on what the role is. When they shut off his email access and turn off the keys.
Cutting off his email access.
No, but the argument can be, well, then what's my damn role? I'm not producing. I'm not doing.
Look, I've been let go from a firm before, and it happens, and it sucks. But I, as an attorney, if I don't have access to my former emails, that actually does cause a significant harm to my ability to protect myself from a legal perspective.
If you're watching, Tucker, please send us your contract so we can discuss this intelligently, because we're feeling like very lost about this. So Tucker, you could just email me or Eric or whatever. We'd appreciate it. Thank you.
I'm standing by. Eric, I'm here for you too.
Can we set that aside for 1 second? Because a similar example would be the argument that I had when it came to, DeSantis. I'm not trying to, you know what? Forget that I said anything.
Hold on, I've got a super chat.
It would totally take it in a sideways direction. And Eric.
No, that's fine. Somebody brought this up. And I believe this is already settled, the Claire Torrey versus Pink Floyd case, but they're pointing out that there could be some relevance here. Claire Torrey is the person who was hired to do Great Gig in the Sky, a completely unique track where she did not sing, she did not scream, she just emitted vocals through the entire song on Dark Side of the Moon. No, it sounds weird when I'm saying, but she's the only person I know of who's ever done it. It is a beautiful, beautiful track that she improvised and is absolutely unique. No words, just emotion. But she never got a credit for it. She was a hired session singer, didn't get the credit for it, and she sued and wound up getting a songwriting credit for that track as well as some money.
Another one that you might be familiar with. It's a very popular one. Well, there's multiple Led Zeppelin lawsuits, but the one that was legitimate, not the Stairway to Heaven Spirit lawsuit, but the one that was legitimate was the Willie Dixon litigation. The first Led Zeppelin album had a lot of Willie Dixon tunes, although I would argue that Zeppelin's take was greatly different. Yeah, but now Willie Dixon is credited, I think, for at least 4 songs in the Zeppelin catalog, based on extensive litigation between Zeppelin and Willie Dixon estate. So these kind of things are all subject to negotiation between employment law attorneys, and in this case, that would be a copyright question. Anyway, I was going to this. All of these things, like what Joe was talking about, it's a negotiating position. The corporate higher ups, probably Murdoch, said, I want him off. Maybe it was due to the Dominion thing. Maybe it was due to the January 6th thing. Who knows what it was? But he said, I want him off. And of course, he's the big boss and everybody obeys him. Now the lawyers get it. Now he's out. And then the lawyers say, hey, wait a second, we didn't fire him. He's still under contract. Now they're trying to play cleanup. And now it's in the hands of the lawyers, and they're going to work out their deal. And I think that how it's going to resolve is there's going to be some negotiated termination. The reason this for cause thing, they've got a file on him of all the bad stuff he does, and they're going to say that was cause. And whether it was cause or not is subject to litigation. It's simply a negotiating point at the negotiating.
I think that's kind of bullshit. And Steve, you know that well enough that this has nothing to do with law at this point. This is win in the public sphere, win public opinion, tarnish the guy, so that it makes it seem perfectly reasonable that we got rid of him. Because God forbid we end up in a courtroom we've already done what we need to do in terms of contaminating a jury.
No, I
What
don't think
about
so.
the
I don't
statement?
agree with that, but I bet it may be an element of it, but I don't think that's the substance of what's going on.
I've seen it happen over and over in Tampa, Florida, multiple times.
Hold on. We had we're overlooking something. The original statement on Monday, Fox went on the air and said that Tucker Carlson and Fox News had separated ways mutually. I forgot.
You believe that for a second?
But remember, that was what they said. They literally said that they had mutually separated. Doesn't that come into relevance? Are we forgetting an important thing that occurred?
I think that's a lie. I genuinely think that's a lie. Excuse me. Because you saw reports as well saying that they were preparing for their Monday show that morning when they were escorted from the building.
Yeah.
Right, but these are all statements. I'm talking about the network put out a statement on air from the network that would seem to have a relevance, legally speaking, that they publicly stated something. So if they said that he's separated, then how can he be under contract with them and literally cooling his heels if they said that he's separated?
I see what you're saying. I see what you're saying is that if they say
It's
that
an admission. He's saying it's an admission against interest for Fox.
Then how is he still under contract?
Right, Joe, you just hit it. Yeah, what happened was Murdoch sold I want him out, and now the lawyers are playing cleanup. This is what and now they're just negotiating. They're trying to. It's a matter of millions of dollars. I mean, if he's got a 5-year contract at $1 million a month, what is that? $60 million. So if we can say it's a for-cause firing, then we don't have to pay the $60 million. So you're fighting over $60 million. That's money worth fighting for, right?
Well, Abby Grossberg, in her filing, I believe that she claimed that Tucker was making $10 million a year, just to get the numbers right.
Well, if it's a 5-year, that's still $50 million.
I also think his contract was set to expire sometime next. I think his contract. I think it was originally perhaps for 33. His contract is set to expire sometime next year. So that's why I think there's all this confusion about the numbers. But Abby Grossberg would probably know. I don't know that she would because she never met him. Abby Grossberg is the producer who's suing Fox and Tucker. So,
who she never actually met,
right?
By the way, which was
and we can talk.
Lawyer.
We can talk about that lawsuit because I read through that 100 pages of just wow.
It's garbage.
You don't have to.
Did you guys read the Abby Grossberg complaint or see it?
I did.
Do you know about this case, Eric?
No, dude. I know nothing. I was joking that you read it, so we don't have to. Thank you.
Oh, you're welcome.
Service.
It's garbage.
I mean, I will say it's well written garbage. I think I think that the attorneys did a phenomenal job of applying lipstick to that pig. But
but it's still a pig.
Right. I think there's so little meat to her claims that she was a victim. This is your classic case of someone who's crying victim when over like literally anything. Like if anyone in the room ever made a joke about women, it's like or used a derogatory term, it's like she took it as if this was an offense against her personally. I mean, that type of approach is something that it's designed to make people feel as uncomfortable around you as possible.
How can you argue that a specific individual created a negative work environment when you never met them?
Oh yeah, I mean, I think the theory.
I think I could argue it. No, I absolutely could argue it. I mean, I was in the military, right? I may never talk to the commander, but everybody under the commander makes my life hell because of the commander's policies. So if you have somebody who's creating,
how do you prove that?
No. So Eric, to bring that home, you're correct in what you just said. To bring that home,
you are correct.
Abby would have to basically establish that he is fostering an environment where people should be intentionally trying to motivate people to be anti-Semitic or misogynistic, which sounds about as likely as him fostering an environment where everyone should try and spit frogs out of their mouths. Like why would anyone he's sending emails, hey, I want to see more misogyny. I'm like, what do you think he's doing to foster that type of environment? It makes no sense. It's ridiculous. And they're not his employees. They're almost definitely Fox employees. So it's like ultimately the producers who she complains about a guy named McMillan, like this guy McMillan. Let's say he's a douchebag. That all of a sudden is now that Tucker is fostering it. It's the most ridiculous thing to name him. You want to go after Fox?
Hey Joe.
Okay.
Hey Joe. Yeah. She didn't name the network as a defendant.
She did. She I think she named like 50 defendants and basically said like, every one of them. And one of them,
I have the complaint somewhere. I'll find it.
And one of them was Tucker, who she later admitted she's never ever met, even though she was his producer for like well over a year, because he was in Maine or Florida and she was in I think in New York. I mean, she complains about anti-Semitism, saying that this guy McMillan, when they brought in bread from a kosher bakery, a week later said, hey, get us some more of that Jew bread.
Oh, and guess
what? That's what she claims. And I'll tell you, as a Jew, I would love it. I would, if someone actually said, like, how is that? Are you kidding me? You're basically saying you like our bread better than like any other bread you've gotten. How is that possibly? And I hate when people take some. This is what's so bothersome to me. It's similar with misogyny. It's like he yells that Sidney Powell he uses a C word, that a derogatory C word, and it's like that's now offensive to her that he's talking about Sidney Powell that way. It's or that there's a Christmas display and there's not.
Can I jump in real quick?
Yeah,
she filed an amended complaint, and Tucker's not on it as a defendant, and I can share it if I'm given permission.
Really? She took him out?
Yeah, she took him out in Delaware.
Interesting. Oh, when did that happen?
That was what is the date? Let me see his signature page. Still 70 some odd pages. That was March 20.
That's really interesting because everyone thinks that I've been doing Spaces a lot. Spaces is like a Twitter feature where you can sit and interact with other people by audio, on a panel with a number of up to like 12 other folks and get paid, but it gives you exposure to potentially, if you're on a big enough space, to literally 10,000 people. I've been on Spaces, and you get to interact with people you never would otherwise interact with. I mean, I was sitting there arguing with Ed Krasenstein, which is like someone who's like a real talking shill for the DNC, who I never would interact with if not for these Twitter Spaces. And I get to what? I've made Mario with Mario Narwhal.
Yeah. Those are the good ones, boy. I got
so I've basically been developing inroads there to become a regular part of the panel.
I have got you at the Mario ones earlier. I didn't know you would, because I saw you in there sometimes speaking about it.
Yeah,
he got me on. He's the one that got me on the Mario one. So.
Oh yeah, no. I actually so now I really, it's really fun, and it's like an easy way to spend my afternoon. I could be sitting here doing work and like just have myself muted for like a half hour at a time, and then just pipe up when something relevant comes. So yeah, I happen to enjoy it, and that's why, by the way, I recommend anyone on Locals knows when I'm there, because I basically pimp out when I go there, which is one of the reasons I push everyone that it's goodlogic.locals.com. That's goodlogic.locals.com. So you need to follow me there. But
and how do you say oil?
What was it? It was goodlogic.locals.com.
How do you spell that so I can write it down?
What? It's logic is LAW, right? Good logic.
Logic.
Good logic. Good not locals. Look, it worked for Viva Barnes, okay? Shut up.
Viva Barnes. Yes.
Yeah, I just want Southern Law to keep quiet. He keeps interrupting and talking over everybody,
The two Steves. I have a problem with Steve's not talking. Both of you.
Well, my problem is, I think Steve said a long time ago, this is going to get worked out and negotiated. And then we've all also said, none of us have seen this contract. So we don't have any idea what's in it. And one of the things when you have a topic that develops energy is you want to superimpose what you already believe in the absence of any facts you may know. which is why, you know, a lot of times representing clients or in businesses, show me the documents, guys. I don't want to hear about how terrible the employee was and all that. Let me see the controlling documents.
Exactly.
And so I like to read this stuff. And so
Steve,
your mic is excellent. Southern Law's mic is the best of all of us, and he's got the best books. He looks like a real lawyer here. Can I ask? I have a question. Can I have a question, class? Can I ask? Southern Law, I don't think we've met before. Can you describe what your practice is and what you do?
Well, I started out in civil litigation and then ended up in-house for a few decades and in business, primarily dealing with M&A stuff and then ultimately running some businesses. So now I do whatever I feel like doing.
Nice.
Yes. Oh, yes. Barton Bella says, do you have my book?
There's a lot of them around here, that's for sure.
You can buy my book at stevegosney.com. Actually, I have 2 books, and I have at least 3 more coming out this year.
Yeah, no, so, Steve, I've listened to you on the other panel, Steve. Well, both Steves, but you guys have some fantastic legal analysis. I'm like, oh my God, I didn't think about that at all. So no. You know, if you're out there, make sure you push that book, and you guys should definitely buy it.
Drop the links in the chat, Steve,
because you guys.
I've been working over there. Well, you know, when that Southern Law's got it right on the money, and that is that anytime somebody would come in, I did civil litigation for 6 years, so I did mostly real estate and probate law. And of course, when people would come in with their problems, they'd talk and talk and talk, and they'd say, "I got this and I got this." I'm like, "Okay, well, let me see the documents." Right? I mean, you have to. That's where you start, especially in contract or real estate law, especially. And, you know, you had to drain the title and find out if there's anything there. What you say is pretty much irrelevant. You know, it may impact once you see the terms and you integrate that with the law, but until you have that, we're just talking out the rear.
Well, and I'll go one step further. Is when I was back in New York, I was doing a mix of medical malpractice and, you know, construction injury law, but the medical malpractice, the paperwork speaks for itself. I mean, really, unless there's some testimony that contradicts the doctor's notes, that's what it is.
Well, okay, go ahead.
I do want to say one thing. Just at this moment, we have about 611 people. And this is the first stream I've been on, obviously, after the passing of Secret Miss Squirrel, who was the super mod in our chat. She was a mod on all of our channels, Joe, everybody. And I just want to just say, you know, my thoughts and prayers are to her family. She was a remarkable person. And those of us who knew her are all touched and miss her greatly. I miss her every day. And she
would have been on this right now, being a mod,
pushing this and telling us, you know, it's emotional, but I don't want to kill the flow too much, but I just think we should just at least acknowledge that she was always a part of these streams and all of our streams, and you know, RIP to our girl, and we miss you, Secret Miss Girl. I can't speak for everybody, but I personally do. And
yes, sir.
I'm dropping a link in chat for anybody who may want to donate to help cover funeral arrangements. I hate saying that, and other things that are obviously coming up at this terrible situation. So
I'll say for my part that when I first started this channel, at this point, I guess almost 8 months ago, she was the kindest, most welcoming individual that even when I wanted to give up over kind of the Christmas season, gave me the kick in the ass I needed to come back and keep doing content. So, yeah.
I didn't personally know Secret McSquirrel. I didn't have very much interaction with her, but she was a regular for all of us. And most people, when they assume that kind of role, end up forming, you know, some fans and some detractors, some haters. And it's a remarkable thing to see someone who seems to be so universally appreciated and respected. That's something that it shows a rare
grace.
Yes, that was the word I was looking for. Thank you. Yeah, a rare grace, and when that light is extinguished, it's a loss for all of us. So rest in
Oh, and
peace.
I'll add on that I didn't know her either, but as a general matter, the mods are amazing. I really like our mods. Of course, I'm a chat. I love being in chat. Sometimes I'll go and I like chat. I'm like, Gosney, come on. I'm like, no, I want to be in chat. That's so fun. And the mods kind of make things. First of all, they promote things while we're talking and doing our business. Second is they keep they keep out all the crazy bots and things like that and keep control. So good mods are precious. And I see we have Ray J here. Thank you for the promotion. But
Yeah.
And so I would just say she's kind of a stand-in for me for mods generally, who I greatly appreciate.
Yeah.
And Ray J actually worked with her quite a lot. I call them the two Scots. So
I was just going to say real quickly, like, I think that's totally true. And that's such a really important point to make, is that, if I'm doing a gavel-to-gavel trial or whatever, when those happen to come up, I have no problem just letting the stream run while I head up to the courthouse to see it in real time, because I trust my mods to do a good job. And so, sorry, I apologize. I cut you off.
The chat is the mosh pit of the internet.
Here's an interesting case that recently came up. Just to switch gears, it's an interesting case that came up. There was a transgendered woman who sued under gender discrimination because I think her employer didn't allow her to the same, like, how if you're a woman, there were some benefits that women got. I think it may be prenatal benefits or something to do with benefits that just only biological women get, and she wanted those benefits also. And they were like, well, no, because you're not a biological woman, you can't get those benefits. I forget what they were, but she sued, and the appeals court said that the suit can go forward because the law because she's now technically a woman. So I was just trying to figure out. My question to the panel is, if that's the case, if now transgendered women can be considered women in for terms of gender of what's it called when it comes to
status?
Not status. It's when you have those cases that go to Supreme Court. How if you're yes the tiers of scrutiny. Is that it now? It to me it seems like it kind of erases that distinction between men, because now if you're a guy who can now identify as a woman and then get all those benefits, like Ruth Bader Ginsburg and all that stuff, all those benefits now that women can get or can sue under, where does that doesn't that kind of erase that whole tier of scrutiny when it comes to gender?
I think that the best argument that you could make would be that transgenderism should be qualified as intermediate scrutiny. That would be as.
Can I jump in before we?
Opinion, but as a lawyer, I think that that's an intermediate scrutiny matter.
Well, here's what we're talking about, okay, and what Nate's talking about, and that is that there's 3 levels of scrutiny that the Supreme Court applies when you have a discrimination action. The first is called strict scrutiny, and that applies to protect certain protected classes, which are at the top level, race. I think it's race, nationality, national origin, things like that. That's called strict scrutiny, and it's the standard. The way it says to pass that. So when the legislature passes a law, it has to undergo a strict scrutiny when it names, say, race. So, like, Asian people are not allowed to get into Harvard, right? And there's a law that says that. Well, then it has to be strict scrutiny applied, and that says the legislature must have passed the law to further a compelling government interest, and it must be narrowly tailored to achieve that interest. That's strict scrutiny. Now, there's also the rational basis test. Rational basis is there has to be some rational basis for it. Sex is the one that is called intermediate scrutiny. And that because there is a difference. The law recognizes that there's a difference between men and women, and they have differing interests, different attributes, and therefore there is a little bit different standard. It's not similar to race. It is something with a little bit less, because like having a female bathroom and a male bathroom, we have a separation of sexes. Well, if it was separation of races, that would fail under strict scrutiny. But because it's separated of sex from sexes, there's an intermediate scrutiny applied, and it passes that basis. So that's what we're talking about. So I'm sorry, because a lot of people are watching, they're not lawyers.
If I may step in real quick, the basis of intermediate scrutiny had nothing to do with separation of bathrooms. It had everything to do with, could you have legally different age requirements when it comes to purchasing alcohol?
Was it VMI? It was VMI, Virginia Military Institute. It's the Ginsburg case that puts intermediate scrutiny on the map.
No,
You're talking about Cohen, the beer, right? And then VMI is the one that then I thought it was VMI.
Yeah, VMI is this.
Was it not the liquor case that?
No, the VMI standard. Let's just kind of I'm sorry, I'm lecturing a little bit, but a lot of people who are watching are not lawyers, and they may. Intermediate scrutiny means that the government must advance a substantial or important government interest in a narrowly tailored way, or a way that does not substantially burden more speech than necessary. And Nate is right. That is that the VMI case, which was one that this is an interesting little factoid. I'm friendly with Clarence Thomas's son, who was going to VMI at the time.
It's very tolerant of you there.
And he had to disqualify. Clarence Thomas had to disqualify himself. VMI is the Virginia Military Institute, which is a Virginia state-run military institute, and females sued to get into VMI, and they applied the intermediate scrutiny standard. And that's why, and they were ultimately forced females into this thing. Okay, sorry,
Let's go back to Craig versus Boren.
Yeah, Craig versus Boren.
Wasn't that the first appearance of this sort of intermediate?
It doesn't matter what the first is. What matters is the concept. So the concept is, I'm explaining the concept. It doesn't matter where it resides. We have 3 levels of scrutiny when the legislature passes laws that affect certain protected classes. Yes. And sex class is of a lesser protection, but greater than a rational basis.
You have the highest level, which everybody knows is, concrete requirements of the government, or I'm phrasing it improperly, with the least restrictive means test is the most applicable.
That's strict.
And then you have, like you said, rational basis. So there's a rational relationship to the purpose of the government, and the law is rationally related to the action. And then intermediate is kind of still undefined to some extent. It's
not. It's clearly defined.
I
just read it.
I respectfully disagree with you that that's a clear definition in law.
Well, law is vague. The language is vague, but the definition is set.
Okay.
Yeah, because before, these transgendered and LGBTQ issues were actually evaluated under rational basis, and then after Lawrence, you have what's kind of rational basis with bite, where it was kind of like a little bit more than rational basis, but not as much as as the intermediate. Yeah, it wasn't really. What's
the standard under in Lawrence? Because I don't remember exactly off the top of my head.
It was like a rational basis with bite, where they were saying that that the government can't do it to just harm a particular group. And then, but now what they're saying is that when you're talking the transgender issues, they're moving it from the kind of rational basis analysis to the intermediate scrutiny analysis under gender. So that's the issue. Should the courts evaluate these transgender issues under the intermediate scrutiny level, or should it still be a rational basis test?
Interesting. Well, and the vague language you're talking about, which exists, which is what is substantial or important government interest, right? Now, the standard is clearly stated. At least it's set. So when you say this court is applying intermediate scrutiny to this issue. Here's the intermediate scrutiny standard. Substantial important. Well, what is substantial important influence? What it may be substantially important to you isn't substantial important to me, right? So that becomes a subjective kind of question. But the standard is fixed within this what they apply.
Okay. Fair enough. I think that we're talking about it. I think we're disagreeing on application, not necessarily the definition. I agree with you on that.
Because
I haven't taken a stand on application.
Yeah, but one of the clear, the selective services, for instance, that was applied to that particular thing where only men had to register, and they were like, hey, why not? And then they said, well, no, this is an important government interest because we want men to fight war. So that was in one case where it was upheld that this type of discrimination against women was okay. Well, actually,
against men, right.
Was okay.
I don't disagree with that.
Yeah, but I'm saying, that's an application of intermediate scrutiny. Where
And it was more than just saying that we don't like women. I've got to jump in on that. Steve, you can too.
Now, the flip side was actually for the benefit of, if you go to the original Craig v. Boren, it was actually to the benefit of women that they could buy alcohol at 18 and not 21, but men had to be 21.
All right, hey, Steve, Southern Law, Steve. You can say that, or agree or disagree, but I would make the point that the separation of men and women in military and selective services for very specific reasons that go beyond just the gender separation. It's facilities and other infrastructure that has to be considered that I've seen firsthand in field environments. And I don't know if you have as well in Fort Bragg, et cetera.
Well, this is how old I am. When I was down there, you couldn't have women in combat arms stuff. So, right. At the command level and things, of course, you had everybody. But if you were down at the unit level, like the SF groups and stuff like that, you couldn't have women in that. Now at airborne school, they had both, but the women would go off and do their PT and the dudes would do their PT, and it was totally different. I did spend some time working at a command down at Bragg where we had, the women would go to PT and the men would do theirs, but there was one chick there who used to do all the dude stuff, even the ruck marches and stuff, and she was a badass. So there are some, I don't doubt that there are some who can do it, but we didn't really have the issue to contend with because it was separate. They didn't have the option to do these things back then. This was, a long time ago, right? This is in the 80s. So Bragg was, it was easy to deal with because everybody knew what the rules were and, and all of that. But what my concern was, and I think a lot of people's was, what's the combat effectiveness if you have guys with a certain attitude towards protecting women and they start to focus on that instead of the mission? But okay, that's their problem. They need to deal with it. Would be what some people say. But the other one was the obvious situation that was occurring there was when you did have training, whether it was basic training or AIT or it was airborne school or whatever, the women would do different things than the men. They never had the women doing pull-ups or push-ups or anything the dudes had to do other than, maybe the core activities. And some of them probably could, but, I wasn't a big guy back then. I could barely get my butt up in the back of a C-130 if I had a full commo load on over 100 pounds in a pack and a weapon and stuff and get out. You didn't jump out the door with that stuff on, you just fell out of it. So, to the women who could do it, congratulations to them. And I'm sure there are some who are stronger than me, but, there were some serious physical requirements for certain of these jobs, very serious physical requirements will wear you out even as a young man. So if they can do it now, congratulations. But back then, they didn't have the option.
There was also hygiene standards because I was at Fort Irwin as part of the Op 4 in the desert, right? And the women had to go back in every 2 days for hygiene purposes and things. And of course we are like, well, wait a minute, we want to go too. But the men, they'll leave them out there for 2-3 weeks, suck it up. But so there was different standards of hygiene and how they had to deal with that. So I just want to point it out, right or wrong, there were reasons why there was some restrictions. And the integration, you mentioned training. Well, a lot of things happen in basic training when both sexes are on the same establishment. Activities do happen. I promise you, they happen. Things.
Well, but even setting that aside, when you're talking about standards, we have. I'm gonna push back a little bit on that because take, for example, Desmond Doss.
Hey, Joe, check chat.
You're freezing up a little bit.
Oh, sorry. Can you hear me?
Yeah, now we got you.
All right. Think about Desmond Doss, who's a Seventh-day Adventist, joined the military as a pure medic. And so he was given Saturdays off as opposed to Sundays. So we have been able to accommodate individuals, but it's done by a different system than necessarily requiring legal intervention, if that makes sense.
You know, but before, because I know we got 15 minutes left, but before we get out of here, we got 2 Florida attorneys in here, and we haven't asked you guys about DeSantis v. Disney. Let us know. What are you guys' opinions on DeSantis v. Disney? It'll be crazy.
Joe had a great stream on it, and we are both deferring to Legal Mindset on this. Legal Mindset's the man when it comes to this. Joe had a great stream on this last night.
Yeah, last night I spent 2 hours basically breaking down.
Whoever would like to speak, I'll take the last word.
Okay, so I was breaking down Legal Eagle's perspective on the battle between Mickey and Ron DeSantis, and his video is so bad. Oh my God. It's just like misunderstanding the law, misapplication of the law. And Legal Mindset had actually done a takedown of the video and breaking down why he was wrong on the law and his perspectives. Because, Legal Eagle's perspective is that Mickey really showed one to DeSantis and DeSantis is screwed. And the new board that came in there is now going to be governing is going to be governing the Reedy Creek district for the next, 1,000 years potentially. And Legal Mindset just broke it down. And he also came from a position that
I have the actual lawsuit on my. I still have that up. I can put it up if you'd like.
It's how many pages is it?
77.
He came from the perspective of, okay, so Legal Eagle is a California attorney trying to break down what the law is and bonds being issued, but from a special district in the state of Florida. He said, I happen to be the guy who writes those bonds. I'm the attorney from Florida who writes I spent years as a niche practice of working for a company that was charged with the responsibility of drafting the very bonds he's talking about here. There's like 5 attorneys in the world. His source, that Legal Eagle's source is Jacob Schumer. Jacob Schumer, I know him. He used to call me with questions on this because he was a general real estate attorney, and I was the guy who handles special district bond issuance. So he would call me for advice.
Florida, in Orlando, in Florida,
yeah,
on this very topic. I mean, Legal Mindset is the guy.
Yeah,
you want to listen to.
He worked for Disney, didn't he?
No,
he said he never worked. He said I never worked for Disney per se. He said I never worked for Disney specifically. He's like, but I've gone through hundreds of these bonds. I know what goes into them. He said, and if you think about it philosophically, just think about this philosophically. What Disney essentially is claiming is that, okay, so a special district, just for those of you who would understand, because it just sounds like a complicated term. Basically, what it means is, how you've seen Indian reservations that
they have a fiefdom in the state of Florida,
right? So it's just like you have reservations in the state of Oklahoma, where it's like whatever law applies to the state of Oklahoma does not apply there. That's why they're able to have casinos and things of that nature. So too, you can have in Florida, and they created this concept specifically for Disney back in 1965, where they have a special district which basically has its own laws and its own regulations.
Isn't legal, though, when you're talking about the reservations, you're talking about.
No, it's perfectly.
I'm giving it. I use the reservations as an analogy. It's not relevant, really.
It's a perfectly valid analogy, though.
I think a better analogy might be a mosquito control district. Let's say the St. Johns County Mosquito Control District that's set up by the state to deal with a specific problem, but it's under the aegis of the state. It's created under the authority of the state of Florida as the sovereign of the land to create. Now, the legislature has plenary authority over that mosquito control district. They can terminate it tomorrow if they want to redesign it and do something else.
So that's the point that I had an argument with a debate with one of my viewers yesterday on my show for about 2.5 hours. And what it was difficult to explain was you having a special dispensation from the government and them saying we would like to terminate this policy is not a punishment under constitutional law. Do you guys agree with me on that?
It all depends on if you could prove the motivations for that change. Like,
how can you possibly prove motivation?
Well, because this happened a lot in race cases, right? It was like you had the ones where it was kind of like the law wasn't written where it mentioned race, but it had the effect. Yick Wo, for instance, was a great example. For those of you who don't know, the Yick Wo case was a case in California where the local government didn't want Asian laundries to exist. So what they did, they passed a law that said the any laundry that was made out of like wood couldn't operate, but if they were made out of brick, they could operate. Happens that 99.9% of all the Asian ones were made out of wood, and 99.9% of the white ones were made out of brick. So they said that law even though it had not only the plan was to close down the Asian ones, but also
it's for an impact argument. I get it.
But just let me finish. And then it also went into the legislative history. So there is a way that you can prove the motive of, even though the law doesn't specifically say that that's the motive, there are ways to prove it. Now, I'm not sure if this applies to this district, but if they can prove that the motivations were because DeSantis didn't like their free speech, so that's why they're doing it, then I think they may have an argument to say, well, even though they have the right to do it, their motivations for doing it is a unconstitutional, they're trying to suppress our rights to speak freely.
Well, except that, really need to go check out the legal mindset breakdown, because there's like 20 different problems with that. One of them is that the whole idea is that Reedy Creek Improvement District is not Disney. So how can Disney say we are being retaliated against when the district itself is a different entity than Disney?
Well, I think the argument is that they own, like 90% of the land in the district.
But the point is this: a bond issuer, Reedy Creek was issuing bonds. That means that they are a government agency, not Disney, not a corporation. And they make in those bond, and this is one of the things that Legal Mindset pointed out, is in those bond issuances, they must swear that they are not a private entity, but they are a public entity, meaning they are not Disney, they are a different entity. So you cannot, on the one hand, be making these public disclosures if in theory, and he said, and I know I've sent emails to Disney. I know that even though they were making those disclosures, that they were consulted and they were the de facto controller of Reedy Creek District, and that's why that's why DeSantis wants to look into it, because there technically could be criminal penalties for fraudulently misrepresenting their bond, the disclosures on their bonds,
unless they were considered a government entity.
But they're saying they're a government entity, but it has to go to Bob Iger of Disney. I don't know if it's Bob Iger involved in the bond issuance.
That makes sense.
But they can't be saying on the one hand we're a public entity, on the other hand everything is controlled by a corporation, because that it can't be a de facto control by the corporation. So for them to come and make a claim saying, hey, you're targeting us because of our free speech, it doesn't make any sense, as Gosney just pointed out, because it can't be targeting them. It's targeting Reedy Creek, and Reedy Creek has made all these different disclosures on record as a matter of law that we are not Disney. So how on earth can that hold up?
Here's part of the issue is I believe it was February 8th.
By the way, Joe, I got a Rumble rant, so money is going to bump it up the line here, and I think it's definitely on point. Somebody wrote in, I do a lot of work in and around construction, And the way this sounds to me is like the LAWA, LAX Airport Authority. They have their own building codes, their own requirements, their own police, etc., but they're under a state versus the federal element. And I thought that was definitely on point. And I think that's my first Rumble rant for this particular show.
And I also want to bring up one of the constitutional cases that I think is on point. Marsh v. Alabama. This is Marsh v. Alabama, the company town that had all and it's the same exact thing. So yes, a company town can have authority of the government. We remember they made the arrest, and then she sued. They said, well, no, we're just a company. And they said, no, even though it's a company town, though you still have to, you can't violate someone's rights because you're a quasi government, because you have the that jurisdiction. So it is possible for a company to be held under those constitutional standards.
But another key point that he made is, okay, so now the source of Reedy Creek having government power is ceded to them by the state of Florida.
Correct.
And the point is this. Now, Reedy Creek is basically saying, well, now that we implemented these rules in this lawsuit, they're saying now we've implemented these rules, the state of Florida can't take back those rules.
No, and I agree with you, Joe, from a political perspective. I think that it was granted by the legislature of Florida and they can take it back. I agree with you 110%.
Right. I wasn't just talking to you. We had a few listeners here who I wanted them to understand as well.
No, that's fair.
You're a very smart guy and you have background here, but not everyone in the audience has the same background. That's why I figured let me help them understand. You know,
the problem that I want to add on to it, not to fight with you, is they're arguing that the dissolution of Reedy Creek and reorganizing it as, what is it, the Central Florida
Tourism District.
Yeah, CFOD. That particular action is the problem. I don't understand how you make that argument. I've read the case back to front multiple times. I had a debate about it literally yesterday afternoon with one of my viewers who came on, who is a resident of Orlando or wherever the hell he is, Osceola. And we can't figure out what that argument is. His perspective is entirely that the motivation is the issue. My point is, fine, but does motivation create a constitutional problem? And Disney's argument is that it's the motivation that creates the constitutional problem, not that the state can't reorganize its own territory. And for the federal government to tell a state how it can and cannot use its own sovereign territory is a devastatingly scary precedent to set. And
that's Nick Wall.
Anyone on the panel can explain that.
But there are hundreds of cases where the federal courts do that exact thing. We could name a whole bunch of civil rights cases where it's the motivation of the actual law.
Is it motivation or the result?
And
the result and tie it to a motivation.
Yeah, but it's an argument. Disney's argument is that listen to DeSantis' words. Listen to what he was saying. The reason why this is happening is because they were saying we don't like this particular.
Did DeSantis pass the law, Nate? Did DeSantis pass the law?
He signed it.
But that's what I'm saying. Their argument.
Did he pass it?
But my response to you is that this is the argument that's being made. The argument that's being made is that the motivations for this are unconstitutional. It's not the fact that they have the power to do it isn't the problem. The problem is why they are doing it is to infringe on Disney's free speech rights. And I think, and no matter what anybody says, I think they have an argument. I'm not saying they're going to win, but they do have an argument. And to say this argument has no legal merit, I don't think also works, because I can just name case after case after case where laws have been struck down for the same exact reason in different things. Yeah, Jim Crow laws, everything. This is how the federal government protects individual rights against state overreach.
I don't agree at all, but I think that the legal mindset is the authority on this, and I will defer to him on this. But I think the analogy fails because this is the domain of property and municipality law and not civil rights law. I think that the Disney is trying to play a delaying game, getting a friendly forum with the federal government by going to the feds. But the domain of law that they think that they're in, that's just a shield. That's just a cover to get them into federal court. I don't think this is going to succeed at all based on, and I did do some property law, but I'm deferring to legal mindsets analysis. And when I listened to him front to back on Joe's show and on his show, actually, both yesterday, it was the best analysis I've ever seen. And I would completely defer. And he is of the opinion it's 100% loser for Disney. And they're just playing a political waiting game, trying to delay it so they can get DeSantis out and maybe a friendly legislature that will change it up for them. That's what they're doing. The civil rights era thing, that ain't going to fly. That's not what's going on. And there's a lot of cases where in fact motivation makes no difference at all. And I'll go back to my little comfort zone of criminal law, and that is the stopping. You know, there used to be a lot of inquiries into police motivations for stopping, and so U.S. Supreme Court did away with that in the case called Wren, WHRENN, in which the subjective motivations of the police officers are irrelevant to the actual stopping of the vehicle. If there was an objective reason for the stop, subjective motivations are not inquired to. So, you know, you had every black person that was arrested by the police would say, I didn't get stopped because of race, right? Well, they said, yes, but you were speeding, or yes, you were fleeing for the cops, or yes, you had a broken windshield or something, you know. And so they said, okay, we're doing away with all this inquiry into subjective motivations. It's only objective. Now, that's a criminal standard. And so I think, therefore, if there's a rational basis, going back to what you'd said earlier, Nate, if there's a rational basis for this change, which there is, they're not going to go any further, I don't think, into the subjective motivations of this.
And the interesting rational basis that they can attach to it is they very artfully, and this is one of the things I pointed out last night.
There's a tax basis. You don't have to go any further than that, Joe.
But hold on. There are rational basis. There are rational basis cases that failed based on motivation. It happens in the LGBT. I forget. It's not Lawrence. Lawrence wasn't the one. There was the one after Lawrence with the was it where they tried to put the mental hospital in a particular place, and then the state said you can't. They you zoned it because they didn't want it, and then they said, well, you're trying to harm this group. I forget the name of the case. But to say that you can't argue that a politician's motivations for passing a law, isn't relevant. There are textbook cases within both civil rights, both LGBT, and that go along this route where these laws have been overturned for that particular reason. So I'm not saying I want to be very. I'm not.
Let me ask you honestly, what precise group is being restricted from speaking as a result of the reformation of the decree?
Me. Every time I speak, John cuts me off.
Go ahead.
Hey, Joe, check your email. Joe, I sent you an email too.
Thank you.
But I want to be very clear. I agree with you guys. I don't think Disney's going to win, but I do think they have an argument in terms of if they could show that DeSantis is only doing this because he wants to stop them from disagreeing with his political views, that the Don't Say Gay bill, which is not a Don't Say Gay bill, it's a ridiculous thing. But with that, then I think they do have an argument, and that's why they're going to federal court.
But you admit the premise. You admit the premise.
Okay, guys, guess what? We're past the cutoff time. Definitely have to wrap it up, but we're going to leave this hanging out there, and we'll fight it out later. I promise somehow, some way through all of LawTube or whatever it's called, because we can't use the word LawTube or what have you. But Mr. Steve Gosney, where can people find you?
The best part of this show, the most important thing of all, is to go to stevegosney.com, get all things Steve Gosney. And I've got 2 books out. I have a greet event coming up. I've got law cards, which you can get lawcards.com. And Joe will say get lawcards/Joe, but I'll just say go to my site. And I will say that there's all kinds of stuff there. And we're going to have lots of fun tonight on Rumble at 8 p.m. It's going to be the return of Gosney tonight. for 8 o'clock on Rumble, and I'll see you all there. And I hope, and then Saturday, I'm actually only reappearing for a moment in time. All the S that's hitting the fan in my life has been delayed by about a week and a half. So I'm sneaking back on for a week. So, but we'll talk about it tonight. So come to Rumble at 8 p.m. tonight, Eastern Standard Time. And thank you all for having me on.
Awesome. Mr. John Robine.
How are you? Robine Law is the best place to find me. I think I haven't decided entirely. I think I'm gonna be covering the Alvin Bragg lawsuit appeal and withdrawal this evening. I'm not entirely certain when, but the best way to know how to do so is to see me at Robine Law over on Twitter.
All right. The other Steve, Mr. Steve Southern Law, who somebody pointed out, has the best sound, but the least used. So I don't know if it's a statement on the quantity or it's the tonal variety, but I think that if I was to pull up the individual streams here, there would just be like occasional blips where Steve actually said something. So please share a piece now where people can find you.
Well, I will say that the devastating impact of this Disney discussion is I'm going to have to read this case because I haven't read it, so I wouldn't know what I was talking about. But now I'm actually interested in it, so I'm going to read it. And I'm not as sad as groomers facing destruction if Disney loses, but I am a little sad that we didn't get to what I thought would be the big fireworks, which is Florida changing its death penalty rule. So, Eric, if you do that in your next stream, people should tune in because before we went live, I thought, boy, you've got an atom bomb tuned up here.
Yeah.
So anyway,
didn't they just bring back hanging?
So if anybody wants to see anything when they wake up tomorrow morning for coffee after everybody else's exciting streams, I got a video coming out tomorrow about Wisconsin changing its constitution to make sure they don't get another Darrell Brooks. That somebody brought that to my attention. So a heartwarming story of something good coming out of a tragedy tomorrow.
Oh, that's good.
Yeah, in standard definition.
All right, now really quickly before Joe, because we always have to give Joe his opportunity to give plugs and a word of wisdom. I will be doing America's Untold Stories later on today with Mark Robert on my channel, Freeform Friday on America's Untold Stories, where if you think we are talking over each other and arguing, well, guess what? We do it all the time on America's Untold Stories on whatever subject is flying through the window. We don't even know what it is. But let's go ahead and close out with Joe's plugs and words of wisdom.
I can't get a plug.
What about Nate? What about Nate?
I can't even get a plug myself. My name is Nate the Lawyer. You guys know me. That's okay. Go ahead, Joe.
No, go ahead. Go ahead. I got rattled.
All right, listen, Nate the Lawyer, you guys know who I am. My channel, I just have all crazy stuff happening. This month has been a great month. I got a 5 million view video, a 1 million view video, and I talk about everything that we're talking about now that has emotional appeal. We talk about it, we get to the nitty gritty, and people hate me, but when you go to the channel, at least one thing you'll do, you'll think, and you'll hear both sides' perspective, and whichever way you come out, it doesn't matter. So Nate the Lawyer, just check me out.
There you go. And I'm Good Logic. You can find me on YouTube as Good Logic. On Rumble, I even have a Facebook page, Good Logic, for those of you who are 80 and over. And you can find me at goodlogic.locals.com. That's goodlogic.locals.com. I have a video with 5,000 views, another one with 1,000 views. You're gonna love my work, and I urge you to check it out. And the one thought that I want to share with every one of you, that really, if you take away anything from this conversation, perhaps the most important thing that you should take away is that when you're trying to figure out